Hello. This video will give you an overview of mortgage foreclosure and will guide you to the other 4 videos on this topic. The other 4 videos will explain your options for avoiding foreclosure, mortgage foreclosure scams, what happens after a foreclosure lawsuit is filed, and what happens after the foreclosure sale of your home. These 4 videos are linked below. If you have missed mortgage payments, you should try to resolve the problem before your lender sues you in court. Call your lender. You may be able to work out a plan to get caught up on your payments before you are sued in court. If you have been sued in court, you should really try to seek alternatives. Your situation will not get better if you do nothing. There are things you can do to try and save your home outside of court. Even if you're being sued, you can still make a plan with your lender to get caught up. You could also try to refinance your mortgage, sell your home, or even file for bankruptcy. View the video, Options for Avoiding Foreclosure, linked below for further details. Do not move. You don't have to move out of your home until the judge tells you that you must move. This can usually take 7 months or more. A normal foreclosure case in court involves the judgment of foreclosure and the order approving sale. It is not until the order approving sale is issued that a judge will tell you you have to move. The order approving sale will normally be issued no less than 7 months after the case is filed in court. Beware of scam artists and predators. You may be contacted by mail, by phone, or in person by people claiming that they can help you save your home. Often, those deals are designed to take money from you without really helping, or even defraud you out of the title to your home and to take all of the value. Do not sign any papers without consulting an attorney. View the Mortgage Foreclosure Scams video linked below for further details. Know what is happening in court. The process will usually take at least 7 months. If you do not participate in the court process, you will not know if and when your home is being sold. The judge cannot give you any extra time to try to save your home if you do not participate. View the video, What Happens Once a Foreclosure Lawsuit is Filed, linked below for further details. If you are unable to keep your home and it is sold in foreclosure, you still have options. There may be money left over from the sale, and you may be able to get some additional time before you move. View the video, What Happens After the Foreclosure Sale, linked below for additional information. Remember, it is possible to save your home from being sold in foreclosure. Hello. This video will teach you about options you have for avoiding foreclosure. You should think about all of them and pursue all options available to you. Even if you're pursuing more than one of these options, you should still attend all court dates in your foreclosure case so you know what's going on in the case. You can read more about these options by clicking on links on this page to more detailed information. You may redeem your mortgage, that is, pay it off, by refinancing. Refinancing is when you take out a new loan that pays off your current loan. You should realize, however, that payments on your new loan will usually be higher than your old loan payments, and your interest rate may increase. If you want to refinance your mortgage, talk to someone at a bank where you have a checking or savings account about getting a loan to refinance your mortgage. You should not respond to flyers in the mail or telephone calls to your home. These are from people seeking to take advantage of those who are frightened about losing their home. Work with a bank or lender that you would want to do business with, even if you are not in trouble. Also, before you obtain a refinance loan, make sure you can afford the new monthly payments, or you will end up back in foreclosure owing more than you did before. Your lender may be willing to work with you and do what is called a workout plan. Exploring the possibility of a workout plan is sometimes called loss mitigation. The resulting plan is often called a forbearance or repayment plan. Basically, this is a way for you to repay what you owe on your mortgage over time without bringing the mortgage current all at once. Often, the lender will ask you to pay a lump sum toward what is owed, then something like 1.5 monthly payments per month for a set period of time. Or, the lender may agree to put your missed payments at the back of the loan. Sometimes, the lender will even be willing to reduce your interest rate. The important thing is to contact your lender and try to work something out. The sooner you contact your lender to pursue a possible workout plan, the better. The process may take a long time. Each time you talk with a representative from your lender, you should take notes, including the date, time, name of representative, and what was said, including the next steps. Make sure to get any agreement from your lender in writing and keep a copy. Your foreclosure case will likely not be dismissed until you have completed the workout plan. You may want to contact a HUD-certified housing counseling agency to help you pursue a workout plan. These are nonprofit agencies certified by the U.S. Department of Housing and Urban Development. They will not charge you a fee. Do not work with any person or agency who charges you an upfront fee to pursue a workout plan with your lender. That person or agency is probably committing fraud and violating the law. You may have legal defenses to the foreclosure action. You should have an attorney review your loan documents to make sure that the proper disclosures about the loan were made to you when you obtained the loan. However, certain remedies are only available to you for a limited period of time. It is important that you act right away and that you do not ignore the situation. If you have refinanced recently and are facing foreclosure, be sure to have an attorney review your loan documents within 3 years of the date you obtained your refinance loan. Bankruptcy is not for everyone. It's most appropriate for homeowners who have suffered a temporary setback and are now in a better financial position. Do not listen to attorneys or others who tell you that bankruptcy is your only option. Instead, talk to a good attorney who knows all the possible solutions when you're behind on your mortgage. These solutions may include bankruptcy, but a good lawyer will never tell you that bankruptcy is the only option for a person who is behind on his or her mortgage. To learn more about whether you should file for loan bankruptcy, search the word bankruptcy on this website. You may want to consider filing a Chapter 13 bankruptcy. Once you file a bankruptcy, the foreclosure case will be stopped, at least temporarily. When you file a Chapter 13 bankruptcy, you are asking the bankruptcy court to approve a plan where you make monthly payments to catch up on your mortgage debt, and possibly other debt, over a period of 3 to 5 years. To succeed in a bankruptcy, you must be able to afford the bankruptcy plan payments and continue to make your monthly mortgage payments. If the court does not think you can afford the plan, or if you do not make your plan payments, your bankruptcy will be dismissed and the lender will be allowed to go back to foreclosure court. If you are 62 years or older, and if you have a lot of home equity, you may consider a reverse mortgage. A reverse mortgage is a mortgage loan against your home that you do not have to pay back as long as you live there. Through a reverse mortgage, you receive payments from the lender, and then you pay the money back plus interest when you die, sell your home, or permanently move out of your home. Finally, if you simply cannot afford to keep your home through any of the options discussed here, you should try to sell your home. If you decide to sell your home, you should put your home on the market as soon as possible so you have the maximum amount of time to sell your home. This will help you sell your home for the best price you can so you can get as much out of your home equity as possible. Home equity is the money left over after paying off your mortgage. The best option is to list your home for sale with a licensed realtor. If the price you get for your home falls short of the amount you owe on your mortgage, your lender may still be willing to work with you. Some lenders are willing to accept this lower amount and forgive any additional amount you owe on your loan. This is called a short sale. Be aware, though, that under a short sale, you may be liable for taxes on whatever debt was forgiven by the lender. The bank may send you a 1099 form which states the amount forgiven and which you must report on your income taxes as income. If you are unable to sell your home, your lender may be willing to accept what is called a deed in lieu. With a deed in lieu, you sign over your home to the lender to satisfy your loan, and then you owe nothing else on the loan. You can sometimes do this before a foreclosure case is filed. Remember, you may have a number of options available for avoiding foreclosure. You may be able to refinance your mortgage, pursue a workout plan with your lender, present defenses to your foreclosure lawsuit, file for bankruptcy, sell your home, enter into a reverse mortgage, or get your lender to accept a deed in lieu. The important thing to remember is to pursue all your options and not ignore the situation. Hello. This video will teach you about different scams to watch out for when facing foreclosure. You can read more about these scams by clicking on links on this page to more detailed information. If you are facing foreclosure, you will receive a lot of solicitations in the mail, over the phone, or even in person at your door. Be cautious of anyone who approaches you offering to help you save your home from foreclosure. No one should approach you outside the courtroom and offer to help. People who solicit you with offers of help may actually just be trying to take advantage of you, and they may try to steal your money, your home, and your home equity. There are even scams you should watch out for after your foreclosure case is completed and your home is sold, if there is money left over after the sale. When you're facing foreclosure, some people will approach you and say they can help you negotiate with your lender, slow down the foreclosure, improve your credit, or obtain a refinance loan for you, and will want to charge you a fee of several $1,000s. And they often want you to pay this fee up front. These are usually empty promises. There are nonprofit agencies that will help you negotiate with your lender for free, or you can hire a lawyer. And there is now a law that requires that such services, if provided for a fee, must be completed before you have to pay any money to the so-called foreclosure consultant. So do not pay any money to anyone without understanding why you are paying the money or before you get what you have been promised. Other people or companies advertise programs through which you can sell your home and rent it back, with the promise that you can then buy your home back when you're on your feet again financially. Sometimes these programs say that your home will be placed in a trust, or that you are not transferring title to your home completely, or that this is just a type of loan. Do not trust these promises unless you have had an attorney review the paperwork. Usually, the repurchase price is set so high that you will not be able to afford to buy your home back, or the rent payments are not affordable, and you can be evicted when you fall behind. Also, once someone else has title to your home, he can take out a new loan on your home. This is how your home equity can be stolen. These types of sale-leaseback transactions are now regulated by state law, and you have certain rights if you enter into one of these deals. Read more about these scams and the requirements of the state law in the information you can link to from this page. Sometimes, after you go through a foreclosure, there will be money left over that you can claim. This is called a surplus. The money is there because the property that was in foreclosure sold at auction for more than what you owed. Once all the debts against the property are satisfied, you can collect this money. The process for collecting the money is described later in this video. Sometimes companies or people will approach you and tell you they will collect your surplus for a percentage of the money that is coming to you. These people may or may not be attorneys. Do not sign papers saying that someone else can have your surplus or that they can work on your behalf. No one but you is allowed to receive your surplus. You do not need an attorney or anyone else to collect your surplus. The process for collecting your surplus is designed to be something you can do yourself. Even if you make a mistake, it is possible to correct the mistake and come back to court. The judges understand that you are new to the court process, and everyone involved will try to make the process easy to understand. Be sure to search the Helpful Organizations section below to find free or low-cost legal assistance. Even if you hire an attorney, you will still be required to come to court and give testimony. And later, you'll need to come to the clerk's office and show identification to collect any surplus. Anyone who tells you they can do these things for you is lying. It is illegal for a non-attorney to offer to do legal work for you. If you decide to hire an attorney to collect your surplus, even though it is not necessary, that attorney should charge you a reasonable fee based on an hourly rate. No one should charge you a percentage of the surplus. Attorneys are not allowed to charge a percentage in these types of cases, and if they do, the charge will usually result in you paying far more than the service is worth. Remember, many people offering to help you for a fee are often trying to steal your money, your home, or your home equity. Search the Helpful Organizations for information on free or low-cost legal assistance. Also, if there's any money left over from the sale of your home, you do not need the help of anyone to claim it. Go to court to claim these funds. Finally, be sure to click on the links on this page for additional information. Hello. This video will teach you about what happens once a mortgage foreclosure lawsuit is filed. A foreclosure lawsuit is usually filed after you've missed 3 mortgage payments. The lawyer for your lender will start the process by filing a complaint in court. The lender is the plaintiff and you are called the defendant. View the video Options for Avoiding Foreclosure linked below for more detailed information on how you can avoid foreclosure. The law requires that you be served with a copy of the complaint and with a summons. You might receive those documents by someone delivering them to you, or they might come in the mail. If they come in the mail might be addressed to you or to unknown owners. Remember, you do not have to move just because you received those papers. Do not ignore those papers. You should do 3 things when you receive the papers. First, try to talk to an attorney. Second, call your lender. Third, file your appearance and answer in court. An attorney can tell you whether the papers were served in the right way, if you have any defenses to the lawsuit, and can help you work with your lender. Be sure to search the Helpful Organizations section below to find free or low-cost legal assistance. You should talk to your lender about alternatives. You have 90 days from the date you were served to bring your payments up to date. This is called reinstatement. You can discuss your options for reinstatement with your lender, such as a payment plan or a change to the terms of your loan. The law gives you 30 days from the date you were served to file an appearance and answer. The summons will tell you where to go to file those things. A fee must be paid to file, but depending on your income, you might be able to have the fee waived. Click on the links on this page for additional information about getting your fees waived. If you file an appearance and answer, the law says that notice of all future court proceedings must be sent to you. If you do not file the appearance and answer, you might not receive important notices. For example, you might not know when your house will be sold or when you may be required to move. The next step in the court process is for the lawyer for the lender to schedule a court date to get a judgment against you. This could happen any time after 30 days from the date you were served. You will probably receive a notice in the mail. You can also get information about the status of your case by checking the records of the clerk of the court. You should not ignore your court case or any notices sent to you. Be sure to attend all your court dates and be on time for court. When you go to court, you should tell the judge if you did not receive the summons and complaint. You should also tell the judge if you are doing anything to try to save your home. This includes any options you are discussing with your lender. Bring any papers with you that will help show the judge what you are doing. You should also tell the judge if you have hired an attorney or if you are trying to hire an attorney. At the first court date, the judge can continue the case or the judge can enter the foreclosure judgment against you. If the case is continued, be sure to get a copy of the judge's order that indicates the next court date before you leave. Be sure to go to court on the next date listed in the order. If the judge enters judgment against you, you still have some rights and you still do not have to move. You have at least 90 days to pay off your loan. This is called redemption. You can pay off the loan by refinancing or selling your home. You may request additional time from the court to sell your home. You should also continue to work with your lender on all options to save your home. If you do not pay off the loan or work out some other agreement with your lender, the lender will sell the property at auction after those 90 days run out. You do not have to move out before the sale. After the auction is held, the lawyer will schedule a court date to ask the judge to give possession of the property to the buyer. Generally, the law allows you 30 days after that court date before you must move. Remember, you should continue to try to bring your mortgage current or pay it off. You should also try to work something out with your lender. Do not ignore papers from the court, and be sure to file your appearance and answer. You should attend all court dates and tell the judge about any plans you have for bringing your mortgage current or for trying to sell your home. Finally, click on the links on this page for additional information. Hello. This video will teach you about what to do after the confirmation of sale has been entered in court. The confirmation of sale is usually the final judgment of foreclosure. There are 4 issues to consider. After the sale, the plaintiff's attorney has to come to court to approve the sale. This is called the confirmation of sale. At this time, the judge will give any person living on the property 30 days to move out. If you need more time, you can come to court to the confirmation of sale proceeding and ask the judge for more time, or you can later file a stay of possession. A stay of possession can extend your time on the property an additional 30 days. You must file your paperwork asking for the stay of possession within 30 days of the confirmation of sale order. When the judge allows the lender to sell your home, the home may sell for less than what you owe the lender. The lender may seek collection on the amount still owed to them. If this happens, you will have a chance to appear in court. At that time, you should consult with an attorney about your options. Bankruptcy is not your only option. You may be able to settle your debt by negotiating with the lender. The house may sell for more than what you owe the lender. The extra money left over from the sale is called a surplus. If there is a surplus, after all debts against the house have been paid, you can go to court to claim the remaining surplus. You should not respond to any offers to collect the surplus for a fee or percentage. The process is designed so that you can collect your own money without any help from an attorney. When you appear in court, you will need your picture ID. The judge will then ask you some questions under oath. It is important when you fill out your paperwork that you send a copy to each party in the foreclosure case. No exceptions. The parties are usually listed on the order approving sale, which is available in your file in the clerk's office. If the lender buys the property for less than what you owe them, according to the judgment of foreclosure sale, you have the right to buy the property from the lender at the same price the lender paid at the foreclosure sale. This is called the special right of redemption. Beware of investors who say they will buy the property inexpensively and allow you to continue living there. Remember, you do not have to move out of your home until 30 days after the sale, and you may request additional time from the court. You may still owe money to your lender after the sale. You may be entitled to a surplus after the sale. Also, you may be entitled to purchase your home back at a lower amount than you owed if the lender bought it at the sale for a lesser amount. Finally, click on the links on this page for additional information.
Fraud Stoppers, man, I owe you guys big time. Thank you.
So you're saying I can ask this cat any question?
The cat is connected to the computer. You just type in the question, it will read his mind. There the answer comes.
You're the man! I've been looking for this for weeks.